Thank you, my lord.
The State Council, what do you have to say to that?
Yes, my lord. Our preliminary objection, the motion the Land Council is talking about is part and parcel of the substantive case. And
yes,
plethora of authorities that where there is notice of preliminary objection challenging the jurisdiction of the court have to hear the notice of preliminary objection, assume jurisdiction for entertaining any other matter. To hear our notice of preliminary objection if the claimant is ready.
okay, thank you, Mr. Indalela. I'm sure you know that it's tried, sir, that if there's an issue of jurisdiction, the court shall hear the issue of jurisdiction first, sir.
My lord?
I said, I'm sure you know that it is tried that if there is an issue of jurisdiction, the issue of jurisdiction should be heard first.
Yes, my lord.
Are you ready to proceed with this?
My lord, may I, at this point, say something?
Yes, sir.
Yes, my lord. My lord, the issue of jurisdiction is without question fundamental.
Yes.
Yes, my lord. But at this point in time, my lord, at this point in time, our application was slated for today, for which they have responded. Now, the issue of jurisdiction here, my lord, is not even asking that from the grounds, if my lord looks at what they are asking for the preliminary objection,
yes,
it is saying that one of the defendants was not given pre-action notice. One defendant is not a juristic person. They never said anything about one of the defendants. They never said anything about one of the defendants. So it's not as if the application they are asking is going to lead to the termination of this suit.
How can you say that, Mr.
It is not going to lead.
How can you say if there's a pre-action, if there's an issue of jurisdiction on pre-action of a conditional a condition precedence to the action, that it will not terminate? You cannot presume that, sir, until we see the facts or your counter affidavit to that effect. You cannot say because if the pre-action notice is fundamental to the action of the case, and if they are saying that it has not been filed, you cannot tell the court that it cannot terminate. You may say it may not, but you cannot say it cannot. And until I see your counter affidavit, then I will know whether it can or it cannot.
As a court pleases. What I'm saying by saying cannot or may not, my lord, I am not preempting the court. What they have filed, this notice of preliminary objection, there are 4 defendants. They are not saying that.
If there's a question as to 3 of the defendants, do you think that the court should proceed with this matter, sir?
Okay, very well, my lord. In the circumstance, what we are saying is that at this interlocutory stage of the matter, I stand to be guided by this honorable. But what we are saying at this interlocutory stage of the matter, they are inviting this honorable court to delve into the substantive matter.
Is interlocutory not part of the substantive? Can we separate the interlocutory away from the substantive?
My lord,
can you on its own, Mr. Lidelela, can you file an action? Can you file an interlocutory interlocutory action without a substantive?
My lord, the interlocutory application is dependent on the existence and sustenance of the substantive action.
And now they are challenging the substantive. Do you think I should just take the interlocutory without looking at the issue of jurisdiction being raised against the substantive?
If that is the case, my lord, may we be
That is the
guided.
position of the law. It is not the case. That's the position of the law.
As the court places, if that is the case, we were served with these processes yesterday.
Yes.
And by the rules of this
Yes.
honorable, we are entitled to, my lord, to respond. We are entitled to time to respond to the application raised by them.
In essence, you're asking for adjournment to respond, sir?
As of right, my lord.
Yes, sir.
No, we are not opposed to the application, right?
Yes, what date, sir? I said, what dates are you intending to come back, sir?
I was subject to the, I was thinking subject to my lord's computer. I don't know when my lord will. Yes.
The court is proceeding on vacation tomorrow, sir.
Wow.
And so if you think it is very urgent, you can make an application to the president to transfer the case to hear it with a vacation judge. But I will give you a date. But if you think that it is really, really urgent and it needs to be heard, then you write an application to the president to transfer it to the vacation judge.
My lord, we have absolute confidence in this court, no doubt. Please put it since tomorrow, my lord is embarking. The court is going to will be given a date that is suitable.
The 4th of October.
So Wednesday, my lord. Sorry.
Yes, sir.
It's okay, my lord.
So like I said, sir, if you think there's a need to have it transferred, please make the application and it will be so transferred to the president to assign to the vacation judge.
My lord, there is, in the light of the fact that the last time counsel announced appearance for 2 defendants. Now he has entered appearance and filed processes for all the defendants.
Then, so that means
all
this
the
one takes over. Sorry? Do you have an issue with that, sir?
My lord, that's where I'm going. I'm trying to learn. I don't have issue. What I'm trying to say is all parties are now fully before this honorable court and represented by counsel. So it therefore means the date given by this honorable court.
Sorry, Mr. Idigbe, what was stated on their memo of appearance? That's what we should observe. Are they appearing for all the defendants in the memo of appearance?
Yes, my lord.
So that settles this, sir. That settles that issue.
What I'm trying to say, my lord, that all parties are before this honorable court So I doubt if anybody will be contemptuous of this honorable court to do anything until that day. That's what I'm trying to say, my lord, that all parties are fully before this honorable court now.
Very well, sir. Thank you. Court case is adjourned to the 4th of October 2023 for hearing.
Thank you, my lord.
Yes, do we have the other parties for the report of settlements so that before I start reading the judgment? Yes, can you call the case again, please?
Case number one. Case number one, NICS/KD/05/2023 between 1 Ibrahim Oladire Yusuf, 2 Ibrahim Abdullahi, and 1 Lawsuit Limited, 2 Lawsuit Limited. Hello,
yes. First claimant present.
Yes, my lord.
Other parties absent. Appearances.
Respectfully, my lord, I am R.A. Josiah. The humble appearances for the first and second claimants.
R.A. Josiah?
Yes, my lord.
Yes.
Sorry, my lord, the defendant's counsel just called. He said he cannot hear. He looked, he was online, but he couldn't hear anything, so he's on his way to the court.
Okay, do we stand it down again?
Yes,
have they filed the report of settlements?
Yes, my lord, I sent it to you.
Okay, I've not seen it. I'll check it. So case 2 down. Can we hear the
My lord, if I may be permitted to take my matter, my lord.
Yes, you can. Which matter is yours?
Is the ex parte. I was online.
Yes, that's the one that we are calling. We had called it earlier, but you were offline, so we had to stand it down.
Yes.
So we will call it now, sir. Yes, sir. Thank you.
Case number 2, NICS/KD/05/2023 between Emmanuel G. and 1 Kaduna State Government, 2 Kaduna State Government Corporation, and 3 Attorney General of another States. And their parties are published.
Yes.
My lord, the parties are absent. My name is J.O.K. Richefe for the judgment creditor applicant.
Yes.
Yes, we have an ex parte application, 2 ex parte applications. Unfortunately, both dated 3rd of July. The one with 28 banks were applying to withdraw.
We have 2 ex parte applications.
Yes, yes.
You're applying.
Yes. One filed
we apply.
To withdraw the one filed on the 7th of July. We're applying to withdraw the one filed on the 7th of July.
Court application granted.
Yes, my lord. The one now
motion filed on 7th July is hereby struck out.
As court pleases. Yes, we have an application also. It's dated 3rd July, but filed on the 23rd July, 2023.
Yes.
Yes, the application is ex parte, seeking for garnishee order NISA in respect of 5 banks.
Yes.
My lord, we move in terms of the application. It's filed on the 23rd July, 2023. We move in terms of the application and we urge my lord to grant it.
Court application granted. An order is hereby issued against the garnishes, namely United Bank for Africa PLC, Guarantee Trust Bank PLC, Zenith Bank PLC, Heritage Bank PLC, and Polaris Bank to show cause why they shall not pay to the applicants the sum of 6,649,834 naira 4 kobo only awarded in favor of the applicants. The judgment debtors had failed or refused to pay, which sum now stands to the credit of the judgment debtors in their accounts with the garnishes. The order shall be served on the judgment debtors and the garnishes. The garnishes shall show cause within 14 days of being served with the order. The matter is further set down till 6th of October 2023 for garnishes to show cause.
I must grateful, my lord.
Yes. Do we have the parties? If they're not ready, please can you call the ruling?
Case number 4, NICS/KD/38/2021 between Mr. Henry Enabole and 11 others. And 1, Nigerian National Petroleum Corporation and 2, Kaduna Refinery Petrochemical Company. Claimants present, 8 claimants present, defendants absent.
Appearances, please.
With utmost humility to my lord, J.K. Lugu humbly appears for the claimant's respondents.
Yes.
My lord, it's with most profound respect to the announced appearance of the defendant applicant. My name is Ibrahim G. Adamu. Ibrahim, capital G, then Adamu. Announcing appearance for the defendant's applicants. Thank you, my lord.
Ruling. The instant application filed on the 7th of June 2023 is praying the court for an order of stay of proceedings of this suit pending the hearing and determination of the appeal against the ruling of this honorable court delivered on the 31st of January 2023. I had carefully considered the totality of the arguments canvassed by learned counsel for both sides with respect to the present application. It is not in doubt that this court is empowered by the provision of Order 64, Rule 14 of its rule to, upon application, exercise its discretion either to grant or refuse an application of this nature. Stay of proceedings is a serious, grave, and fundamental interruption in the right that a party has to conduct its litigation in the trial on the basis of the merits of this case. Consequently, the court's general practice is that a stay of proceedings should not be imposed unless the proceedings, beyond all reasonable doubt, ought not to be allowed to continue. See the cases of Chief Fawanyemi versus Akilu and the case of Nikki Fishing Company Limited versus Lavina Corporations. Citations supplied. The principles that guides the court in the exercise of its discretion are adequately captured by respective learned counsel in their written addresses. Some of the factors that constitute special and exceptional circumstances include there must be a pending appeal that must be agreeable to whether the interlocutory appeal, if successful, will dispose the proceedings in the trial court. 3, the rest will be destroyed, damaged, or annihilated before the matter is disposed. 4, where it will result to greater hardship if application is refused, and 5, where it will render the order of the appellate court nugatory. See the cases of Gomwalk versus Okusa, Allmark Bank Limited versus Akaluso, citation supplied. The cases of Prince Titus Arojoye versus UBA and another, NNPC versus OE Nigeria Limited, Saraki versus Kotoye, Nwabweze versus Nwosu, cited by the Learned Counsel for the applicants are apposite. It is equally trite that a court has discretionary power to exercise in the matter, and like every other discretionary power, it must be exercised judicially and judiciously. In other words, the discretionary power must not be exercised in vacuum, but in relation to the existing facts of a particular case before the court. An applicant seeking the equitable relief for stay of proceedings must satisfactorily establish that the interlocutory appeal will dispose the substantive case, where the grant of a stay will unnecessarily delay the procedure. Stay of proceedings will not be granted. The simple task the court is therefore to undertake now is to examine the facts as set out in the totality of the affidavit evidence filed to support and the counter affidavits to oppose same, in order to determine whether or not the present applicants have disclosed the existence of such exceptional or special circumstances to sway the mind of the court in their favor, and sufficient materials must be available before a court can exercise its discretion. The facts made available by the applicants are stated in paragraphs 4, 5, and 6 of the affidavit in support of the application, namely that the applicant's application challenging the jurisdiction of the court was dismissed by this court, that being dissatisfied, a notice of appeal was filed, and exhibits A and 1 attached as evidenced, that an appeal has been entered by compilation and transmission of the records to the Court of Appeal, and that there is a need to stay for the proceedings. The submission of Learned Counsel is that issue of jurisdiction of a court is question of law that is crucial and fundamental, and further argue that sufficient materials have been placed for the courts to exercise its discretion in favor of the applicants. Learned Counsel for the respondent submitted that the onus is on the applicants to place sufficient materials before the court for the grant of the present application. Learned Counsel argued that the appeal is against a ruling that since the rest of the matter is yet to be determined, this honorable court is fully seized of the jurisdiction to hear and determine the substantive matter, that merely stating that the appeal is on ground of jurisdiction without considering the circumstances of the case will not sway the mind of the court in the applicant's favor. Learned Counsel further argued that the applicants have not shown that the hearing of the substantive matter together with the appeal will occasion injustice. Learned Counsel also submitted that the applicants have not placed enough sufficient materials before the court in the grant of the application. She placed reliance on the cases of Ikpeazu versus Ogia and others, Silva versus FRN, and Akilu versus Fawaini, citation supplied. It is trite and as correctly submitted by Learned Counsel for the applicants that where issue of jurisdiction is involved in the pending appeal, a court is bound to grant an application of stay of proceeding pending the determination of appeal. I am, however, quick to state that merely stating ground of jurisdiction as factor for consideration of the grant of the present application and no more is not sufficient. To put it differently, a court should not be swayed by the mere raising of jurisdiction to fold its arm and to simply for that reason grant stay of proceedings. It is always very important to draw a distinction between the mere raising of jurisdiction in an appeal and the real involvement of jurisdiction in the appeal. Jurisdiction is a matter of law handed out by either an enabling statute or the Constitution. Therefore, before granting stay of proceedings on an issue of jurisdiction, a court faced with an application of stay must be fully satisfied and convinced that there is really a genuine issue of jurisdiction involved in the matter sought to be stayed. See the cases of Eze versus Okolonji and the case of Federal Republic of Nigeria versus Abacha, citations supplied. Going further, by Order 64, Rule 14.1, paragraph rules of this court, party seeking for stay of proceedings pending appeal shall exhibit evidence that leave has been granted by the Court of Appeal, where leave is required either by law or by the rules of the practice direction of the Court of Appeal. The law is that a litigant who is not satisfied with the decisions of this court can only appeal as of right, where such decision relates to questions of fundamental rights as contained in Chapter 4 of the 1999 Constitution, as amended, or in criminal cases as they relate to matters upon which the court has jurisdiction. As to other causes or matter not so specified, appeal shall only lie from decision of this court to the Court of Appeal, as may be prescribed by an Act of National Assembly, and such appeal shall be with leave of the Court of Appeal only. The word decision is defined in Section 318 sub 1 of the 1999 Constitution, the Federal Republic of Nigeria, as amended as, I quote, any determination of courts and includes judgment, decree, order, conviction, sentence, or recommendation. In Skybank PLC versus Hiwu, 2017 Law Pavilion Electronic Law Report 42595, where is a JSC on the issue of obtaining leave of Court of Appeal for decisions of this court, stated categorically as follows. I quote, the combined provision of Section 26(2)(b), 240, 243, and 254(c), 5 and 6 of the 1999 Constitution as amended create a right of appeal from a decision of the National Industrial Court to the Court of Appeal. Such an appeal is as of right of fundamental rights cases in criminal matters and with leave of Court of Appeal in all other civil matters where the National Industrial Court exercises its jurisdiction. End of quote. See also the cases of University of Benin and others versus Ojo, and Section 2443 sub 3 of Constitution Federal Republic of Nigeria as amended, and Section 92 of National Industrial Courts Act 2006. As prescribed by the law, the applicants require the leave of the Court of Appeal to ventilate their grievance, but have not exhibited evidence that leave of the Court of Appeal has been obtained against the decision of the court. The mere filing of the appeal, as it were, without obtaining the leave of the Court of Appeal is incompetent. On the basis of the foregoing analysis, therefore, it is my firm view that the application lacks in merit for lack of sufficient evidence. It shall be, and it is hereby accordingly dismissed, and make an award of 50,000 naira cost against the applicants.
My Lord, we are very grateful for this well-detailed ruling of my Lord, which clearly went even deeper than the written addresses that we supplied. We are very grateful, my Lord, for being so detailed in your ruling. And to be very honest, I have learned seriously an aspect I never really averted my mind to. We are very grateful.
Lord, I'm equally very grateful for your well-researched ruling. Every time I come here, I learn one thing about that. But I also need to disclose to the court that we actually filed an application for leave, which is pending at the Court of Appeal. Because the issue, whether or not leave, I'm just saying this now, this has nothing to do with the ruling of my Lord. The issue, whether or not leave is required on issues of jurisdiction before filing an before filing an appeal is still an issue that is neither here nor there, because in my application before the court seeking leave, I have clearly stated that it is because for the avoidance of doubt, that even though we filed the appeal and transmitted record, we are seeking leave of court to regularize what we have filed. I don't know if my learned friend has been served with that application, but I just feel, speaking from the bar, I need to disclose this to the court. That doesn't take anything out from their well-considered ruling. But moving forward, my lord, I don't know what we do from here henceforth, because as I've disclosed, there is a pending application before the Court of Appeal seeking leave. Thank you, my lord.
Thank you.
How long we shall be applying for a date?
Yes, the case is adjourned to, yes, I'll give you a date for adjournment of the hearing. The application for stay, as far as I'm concerned, Learned Counsel, the application for stay has been refused. That is my business in this court. Whatever obtains in the Court of Appeal, you deal with it at the Court of Appeal level. So the case shall be adjourned. Hearing.
As the court please.
Very grateful.
Court case is adjourned to the 12th of October, 2023 for hearing.
As the court please. I leave with the permission of the court.
Yes, have a great day, sir. Yes, are they ready, the settlements? First claimant present, other parties absent. R.A. Josiah for the first and second claimants. Who is representing the defendant?
You know, my name is Sani SS.
Sani.
Shehu.
Sorry, I didn't hear the name.
Shehu
Sanusi.
The Lord is Sunusi SU, my Lord. Sunusi.
Okay, I've corrected it. Sanusi.
My Lord, Sunusi.
Anyway, just proceed. When I get there, well, when I see the copy of your something, I will amend it on the record, please. So what's the case for today, sir? You are for the defendant?
I am for the defendant.
Thank you. Yes. Yes.
It is for settlement and we are ready.
When was it filed?
It was filed today, my lord.
Mm-hmm. Yes.
Lord, our terms of settlement is dated the 25th day of July, 2023, and filed on the 27th day of July, 2023.
Yes.
Subject to the contents of this one, courts may adopt the terms of this court. as agreed by both parties as the consent judgment of this one.
Yes, Mr. Defense Counsel, because I don't want to upset you.
That is the position.
This is the position? Yes.
That is the position. My name is not that difficult. We have the area Sunusi of Colonel, and I think my Lord take judicial nurses officer.
Yes, I said it, but you were still changing and changing. I said Sanusi, and you said it is somehow called. So I had to drop it because you know we're on virtual and the data can go off at any time. So I shouldn't waste time unnecessarily on what I can correct on the record by getting the proper name. So don't worry about that, sir. So this is the position with the defendant.
Position belongs.
Thank you. Court parties have filed the terms of settlement on the 27th of July 2023. The court hereby enters consent judgments as agreed by parties. So the details will be stated on the face of the judgments. It's just to save the time of the court now.
That's court, please.
Okay, thank you. Yes, thank you. Yes.
Case number 5, NIC/K/22/2021 between Abubakar Suleiman and 1 and Suleiman Personal Service 2, Service Board. And the parties
Appearances.
With profound respect, my lord. I am Halilu Baba.
What's the name?
Halilu Baba, my lord.
Who are you representing?
I represent the claimant, my lord.
Any representation for defendants? Is he online?
No.
Was it served with the notice?
Yes.
Judgment. By complaints and statements of facts filed in this court on the 21st of June, 2021, the claimant claims against the defendants the relief set out as follows. We have five reliefs or 6. Skip to save the time of the court. At the plenary trial, the claimant testified for himself and called no other witness. He adopted his written statement on oath and tendered 16 documents as exhibits. He was duly subjected to cross-examination by the defendant's learned counsel. As gleaned from the statement of facts, the claimant was employed by the defendant in 1988, and his last posting was in Abakaliki under the Enugu State Command of the first defendant. His case, in a nutshell, is that an allegation of absence from duty was leveled against him by the Side Enugu Area Command, and he was issued with a query, but was cleared based on his explanation that he was on sick leave. However, despite being cleared of the allegation, his salary was stopped, and he was not invited to appear before a disciplinary committee until after 4 years. According to the claimant, the disciplinary committee found him innocent of the allegation, and his personal emolument forms were submitted by the command, but the defendants have since refused to reinstate or pay his salaries and other entitlements. The defendants joined issues with the claimants by filing a joint statement of defense on the 15th of July, 2021. One ASC2 AA Adeshida testified on behalf of the defendants as the sole witness. He equally adopted his witness statement on oath as his evidence of chief and tendered one document to support the defendant's case. The gist of the defense as advanced in the amended statement of defense filed on the 27th of January 2022 and the additional witness statement on oath filed on the 16th of March 2022, both with the leave of court, is that the claimant is unknown to the defendant, that he was neither employed or promoted by the defendant at any time. The testimony of DW1 is that an employee of the defendant cannot leave his duty post without a permit to travel. That is at June 2004, the Suleiman AJ that worked with the defendants was ASC2 and not DSC as claimed, and that the defendants never got the directive of the House of Representatives to reinstate the claimant. The defendants further contend that the court lacks the jurisdiction to entertain the claimant's case, as same is statute barred, having been instituted 17 years after the course of action accrued. In the reply to the statement of defense filed on the 11th of February 2022, the claimant contends that the defendant cannot deny that he was unknown and that his rank is Deputy Superintendent of Customs, or that he was at any time sick. At the close of trial, parties filed and exchanged their written final addresses as prescribed by the provisions of Order 45 of the rules of this court. In the address deemed filed on the 31st of January and settled by Olumayowa O. Ajayi Esquire of counsel for the defendants, 2 issues were canvassed as having a reason for determination in the suit, namely, 1, whether this honorable court has jurisdiction to entertain the case where no pre-action notice was served and the matter is statute barred, and 2, whether the claimant has proved his case to be entitled to the claims in this suit. In the final address filed on behalf of the claimant on the 21st of February 2023, his learned counsel Hamed H. Dameguta Esquire identified 3 issues as a reason for determination in this suit. Namely, is the claimant an employee of the defendant? Has the claimant suffered any injury from the actions of the defendant? And 3, is the claimant's suit properly before the court? The defendant's reply on points of law was deemed filed on the 28th of April 2023. For starters, I note that the learned defendant's counsel raised issues of jurisdiction of the court and the competency of the suit in his written address that were hinged on 2 grounds, namely, 1, that the pre-action notice was not served on the second defendant, and 2, that the action is statute barred, citing the authority of Emeka versus Okorafor and the case of Niger Care Development Company Limited versus Adamawa State Water Board and others, citations supplied. Learned Counsel submitted that failure to serve process where service of process is required is a fundamental vice and derives the trial court of the necessary competence and jurisdiction to entertain the suit. Learned Counsel argued that the claimant ought to prove that the service was made through ABEX courier service to support that the pre-action notice was served on the second defendant, and submitted that for failure to serve statutory pre-action notice on the second defendant as required by Section 6(1) Nigerian Customs Service Board Act, the suit as presently constituted is incompetent on the issue of statute bar. Learned Counsel argued further that subsection 2 of the said acts, of the subsection of the acts, has caught up with the suit in that the claimant commenced the action after the time permitted for filing an action against the board, that is the second defendant, complained of, had lapsed. Learned Counsel argued that the claimant's cause of action, as disclosed in the statement of facts, arose 16 years ago, when the claimant's salary was stopped. Learned Counsel submitted that the action is statute barred, having been instituted outside the 3 months allowed by the said act, that is, from the date of the accrual of the cause of action, and finally urged the courts to dismiss, saying, for want of jurisdiction. On his part, Learned Counsel for the claimant argued that the claimant has proved by Exhibit C6B, the acknowledged copy of the pre-action notice, the same was served on the defendant, and as thereby complied with the requirements of pre-action notice as stipulated by Section 6 of the Act. Now I have taken liberty to reproduce Section 6 of the Nigerian Customs Service Board Act 1992 in issue. It provides, I skip the provision of the act is stated on the face of the judgment. I skip to save the time of the court. It is now settled and as correctly submitted by respective learned counsel of both parties, the issue of a cause jurisdiction is the bedrock of a case and fundamental to the question of the competence of the courts adjudicating. Therefore, it is an exhibition of wisdom to have the issue of jurisdiction or competence determined before embarking on the hearing and determination of the substantive suit. So the case of Musconi Limited versus Aspina, the case of B.S. Shitabe versus Attorney General Federation, and Sadisio and other versus Mobology and others, citation also applied. Essentially, the rationale behind the jurisprudence of pre-action notice is to enable the defendant know in advance their anticipated action and to decide what to do in the matter, whether to negotiate or reach a compromise or have another look at the matter in relation to the issues and decide whether it is more expedient to submit to jurisdiction and have a pronouncement on the points in controversy. See the case of Amadi versus NNPC, 2000, 10 Nigeria Weekly Law Report, part 674 at page 76. It is equally settled and as correctly submitted by Learned Defendants Counsel, that's where it is shown that there has been non-service of pre-action notice. The court is bound to hold that the claimant has not fulfilled a precondition for instituting his action. In other words, where there is non-compliance with a stipulated pre-action condition for setting a legal process in motion, any suit instituted in contravention of the relevant law is incompetent, and the court of law for that reason lacks jurisdictional power to entertain it. See the cases of Noye versus Ayichi and Ingberudu versus Ecobank Limited, citation supplied. In the present case, the Learned Defendants Counsel conversed in his written address that the stamp of the second defendant is not affixed on Exhibit C6B, the acknowledged copy, to show that the pre-action notice was served on the second defendant. In essence, The complaint is that there is no proof of service of the pre-action notice on the second defendant. I should remark that it is not on the records of the court that the claimants testified that the pre-action notice was served by courier service, contrary to the arguments of the learned defendant's counsel. The testimony of the claimant is that the pre-action notice was served on the defendant and Exhibit C6B was tendered in evidence as proof of the acknowledged copy. I had carefully reviewed the content of Exhibit C6B, the acknowledged copy of the pre-action notice. It was addressed to the chairman of the second defendant and copied to the controller of the first defendant. The said exhibit was marked as received by both defendants and authenticated and dated as received. By the said exhibit C6B, the claimant has proved that the defendants were served with the pre-action notices as prescribed by the Act, and I so hold. On the issue of the claimant's being statute barred, on the issue of the claimant's case being statute barred, permits me to restate the settled position of law that in order to determine whether or not a court can exercise jurisdiction over a matter, it is the facts averred in the complaint and statement of facts and the reliefs and those therein alone that the court is required to examine in no more. See the cases of Moyosore versus Governor of Kwara State and Guinness Nigeria PLC versus SKA Nigeria Limited. Citations apply. Now the principles that guide the court in determining whether or not an action is statute barred, well settled and well to know. These principles have also been adequately captured and canvassed by learned defendant's counsel in his written address. Without having to recapitulate the said principles, it suffices to restate that the overriding factor or consideration is that the essence of the limitation law is that legal right to enforce an action is not a perpetual right, but a right generally limited by statute, as correctly submitted by learned defendant's counsel. While the statute of limitation prescribes a period within which an action should be brought, legal proceedings cannot be properly or validly instituted after the expiration of the prescribed period. Therefore, an action which is not brought within the prescribed period offends the provision of the law and thus could not give rise to a cause of action. So the case of Yari versus National Salaries and Wages and Income Commission, 2013, Law Pavilion Electronic Law Report at 20520, has gleaned from the statement of facts the claimant's grievance against the defendants for a suspension and non-payment of a salary has been continuous for over 16 years and without redress, and is principally seeking an order of the court directing the defendants for his reinstatement and payment of his salaries. The testimony of the claimants, and as established by Exhibit C6, C6A, and C6B, is that he has made several efforts and sent representations over the years to the defendants, but all his efforts yielded no positive results as the defendants continued to deprive him of his entitlements. It is equally on record that the claimant made an appeal to the defendants in Exhibit C7, dated the 7th of June 2021, and the instant suit was filed on the 21st of June 2021. It must be stressed that the injury allegedly suffered by the claimant is tantamount to a continuous damage which has not been abated or ceased as provided by Section 6(1) of the Act, as held in Oludele versus Wema Bank PLC, as Saboro versus Pan Ocean Oil Company Nigeria Limited, citation supplied. I am of the respected view that the claimant's action falls within the purview of the exception of continuous damage, as the alleged non-payment of the salaries and entitlements was unabated. In such a situation of continuous of damage or injury as alleged by the claimant, the defense that the claim is statute barred is not available to the defendants, and I so hold. Having considered in depth the arguments of the parties, I will say that the academic gymnastics of the learned Defendants Counsel on the preliminary issue raised have been adequately determined. I now proceed to determine the main action. I should state that I had had a good privilege of the written and oral submissions of respective learned counsel for the contents inside, which was argued on the 28th of April 2023. I shall make specific reference only to the submission of learned counsel that I consider as very salient to the determination of the various issues raised as I deem necessary. As I earlier stated, the crux of the claimant's case is the refusal of the defendants for his reinstatement and non-payment of the salaries and entitlements after he had been cleared of the allegation of absence from duty post from the Abakaliki Ebonyi State under the Enugu Area Command. The claimant's testimony is that he traveled on the 20th of March 2004 to Kaduna to assess his salary, but he took ill. That after he received medical treatment, he resumed at his duty post on the 27th of March 2004. That the sickness relapsed and he was issued sick leave at the Federal Medical Center, Abakaliki, from the 22nd of May 2004 to 29th of May 2004, and traveled to Kaduna. That while he on the sick leave, he received information from Enugu Area Command that he had been declared missing. That he reported back to his command and he was cleared by the area command with one DSC Omar II, who had also been declared missing. The sick leave certificate issued at the Federal Medical Center, Abakaliki, the drug prescription, ultrasound report of Medicare Ultrasound Center, Kaduna, and letter of permission to attend interview, that is the letter of clearance, were respectively tendered in evidence as exhibits C3, C3B, C3C, and C4A. The claimants testified further that despite being cleared, his salary was stopped and was issued a query that he responded to the query, but he was not invited to appear before a disciplinary committee until after 4 years of a suspension and without pay. That the disciplinary committee found him innocent and his personal emolument form was submitted by his command for his salary, but that the defendant still refused to pay, and that in 2014, after 10 years of a suspension, he was requested to present a letter of confirmation of his medical service to the command. The claimants further testified that in spite of his appeals, the intervention of the Joint House on Public Petitions and House Committee on Customs, and the letters of demand by solicitors, he has been deprived of his promotion, and but for his ordeal, he will have been promoted to the rank of Deputy Controller of Customs. And also testified that he has suffered damages, psychological and financially, by the defendant's action. The following were respectively admitted in evidence in proof of the claimant's case. Exhibit C4B, that is the reply to query. Exhibit C4, that is invitation to service disciplinary committee. Exhibit C5, that is submission of year 2004 2009 personal emolument forms. Exhibit C3A, that is confirmation of issuance of sick leave certificate. Exhibit C6, C6A and C6B, that is claimant solicitor's letters. Exhibit C7, claimant's letter of appeal. And Exhibit C7B, defendant's reply to the letter of appeal. Basically, the defense put forward by the defendants is that the claimant was never employed in the service of the defendants, that he never served at the Abakaliki office, that he was not given any permission to travel out of the duty post, that the letter dated 8th of June 2004, that is Exhibit C4A, is not genuine, that the claimant, not being an employee of the defendants, cannot attend any disciplinary committee, and that the staff of the defendants bearing Suleiman A.J. as at 2004 was Assistant Superintendent of Custom Dues. The defendants tendered a letter dated the 25th of May 2004, that is Exhibit D1, in support of the defense. At this juncture, I should re-emphasize that the purpose of a reply on points of law is not meant for the party replying on points of law to re-argue its case or bring its point. Bringing points, it's for God to advance when it filed its final written address. It is not a form to engage in arguments at large. Alternatively put, a reply on points of law is not meant to improve on the quality of written address. A reply brief is not a repair kit to correct or put right an error or lacuna in the initial brief of arguments. See the cases of Augustine Mosier and others versus Chico Malu, the case of Bazinko Motors Limited versus Warreman, EcoBank Nigeria Limited versus Anchorage, Leisures Limited and others. Citations all supplied. I have perused the reply on points of law filed by the Learned Defendants Council. The entirety of the arguments, Learned Council, the entirety of the argument of Learned Council on the proof of the claimant's employment and clarification of his initials in his reply on points of law is an attempt to re-argue his case and is hereby discountenanced. The further argument of Learned Defendants Council is that the promotion notification as contained in Exhibit C2 was to take effect from 1996, and that impliedly the claimant alleged that he was promoted to the rank of DSC in 1996. In essence, Learned Council's argument is that the claimant has failed to prove that he is the same person as Suleiman A.G., who was promoted and with the same service number 36891. It is trite that by Section 136 of the Evidence Act 2011, the burden of proof as to any particular facts lies on that person who wishes the court to believe in its existence unless it is provided by any law that the proof of that fact shall lie on any particular person. The burden may in the course of a case be shifted from one side to the other. Thus, prohibition of the Evidence Act supra has been considered by the courts in a plethora of authorities. So the cases of Honorable versus Umba, Ntuama versus Akpeime, Nzeba versus Ibeneme, and other citation also applied. It is clear from the above authorities and the plethora of cases on the burden of proof that in order to discover where the burden of proof lies in a civil case, the court has a duty to peruse the entirety of both the parties. It is also the consensus of case authorities that in civil cases, the burden of proof initially lies on the claimant. In other words, in civil cases, the claimant has the initial burden to lead evidence to prove his assertion, but the burden of proof is not static. Once the claimant establishes a prima facie case, the burden of leading evidence in rebuttal shifts on the defendants and vice versa. I've carefully waded through the entire evidence adduced by the parties. The claimant had tendered Exhibit C1, his letter of provisional or temporary appointment, to establish that he was employed by the defendants. However, the defendants contend that the name Suleiman A.G. with number 36891 on serial number 358 of Exhibit C2, the notification of promotion issued by the defendant is different from the claimant. While answering questions on the cross-examination, DW1 admitted that Exhibit C2 and Exhibit D1 both have number 36891 as the service number for Suleiman AJ and Suleiman AJ, AG and AJ. That service numbers can be allocated to two officers, but that he has no knowledge if the claimant's case is that of allocation of same service number to different officers. Still on the cross-examination, DW1 testified as follows, I quote, the person that bears the name of the claimant is ACSC2 and not DSC. I have not seen or heard anyone claiming the service number of the claimant. The claimant is my senior. I do not know when he was appointed and when he had his promotion, end of quote. I should further remark that the defendants place reliance on Exhibit D1 to prove that Suleiman AJ is not the same person as the claimant. The said exhibit dated 27th of May 2004. The said exhibit is dated. However, Exhibit C4, invitation to appear before Service Disciplinary Committee of 4th of March 2008, Exhibit C4A, letter of clearance dated 8th of June 2004, Exhibit C5, submission of personal emoluments form dated 14th of November 2008, Exhibit C7, letter of appeal dated the 7th of June 2021. Exhibit C7A, reply to letter of appeal dated 22nd of June 2021, tendered by the claimant, all have the rank stated as DSC. With particular reference to Exhibit C5, a letter for submission of the year 2009 personal emolument forms in respect of the claimants and DSC Omar, and for their salaries, the claimants had testified that one DSC Omar II was also cleared for allegation of absence of duty, and that their personal emolument forms were submitted for the payment of their salaries. I make further note that Exhibit D1 tendered by the defendant also has the name DS Omar on the list of officers whose salary are to be stopped. Now, in Section 1371 Evidence Act 2011, the standard of proof in civil cases is on the preponderance of evidence or the balance of probabilities. This rule simply means that the evidence adduced by the claimant should be put on one side of the imaginary scale, and the evidence adduced by the defendant put on the other side of the scale and weighed together, not by the number of witnesses called by either side, but by evidence of probative and qualitative value to see which side preponderates. See Mortgagee versus Odafi, 1978, for Supreme Court 91, where the Apex Court held that preponderance of evidence has to do with the evidence that has the most convincing force, and it is sufficient to incline a fair and impartial mind to one side of the issue rather than the other. See also the cases of Jack and White, Okorie versus Ukalaba, citations supplied. The defendants alleged in paragraph 7 of the amended statement of defense that the letter, Exhibit C4A, is not genuine, and the burden had shifted to them to prove the assertion. Applying the principle in Mortgagee versus Odofin Sucre, I totally agree with the submission of learned claimant's counsel that these exhibits have led credence to the fact that the claimant has the fact that the claimant is an employee of the defendant, and the claimant has consistently maintained that his service number is 36891. Curiously, the claimant had addressed the defendants with a service number and rank in Exhibit C7A, reply to the claimant's letter. Based on the foregoing, the defendants have no basis to deny that the claimant is an employee. In other words, the claimant with service number 36891 is an employee of the defendants. And I so hold. Now the task the court is to undertake is to examine the evidence on record as adduced by the claimant in order to determine whether or not the evidence has satisfied the requirements of proof imposed by provisions of Section 131 and 132 Evidence Act 2011 as amended to substantiate the claimant's claims as endorsed in paragraph 37 of a statement of facts. As correctly submitted by the Claimant's Counsel, suspension is a temporary relief of the duties of an employee for a definite or indefinite period with a view of allowing the employer conduct investigations on allegations of misconduct or any other breaches made against an employee. In the regulation of employment relationship, the power to suspend an employee is not an implied term in an ordinary contract between an employer and an employee. Such a power can only be the creation of either statute governing the contract or of an express term in the contract itself. And in the absence of it, the employer will have no power to suspend an employee. And if it does, it will have to pay wages during the purported period of suspension. The English cases of Van Lake versus Pears and Partners Limited, Marshall and Midnight Electric, citations supplied, which have been applied by this court in a number of cases, such as Mrs. Abdurrahman Yetunde Mariam versus University of Ilorin Teaching Hospital Management Board and another, and the case of Mr. Bisiriu Adegoke Shell versus Lagos NURT First BRT Cooperative Society Limited, held that the employers cannot suspend without pay where there is no express or contractual right to do so. The rationale is that in suspending an employee without pay, the employer has taken it upon itself to assess its own damages for the employee's misconduct at the sum which will be represented by the wages of the days the employee remains suspended. The cases of University of Calabar versus Esiaga, Udelonge versus First Bank, PLC, Udeme versus Nigeria Coal Corporation Limited, Mia Penn versus Unijohns Consultancy Limited, cited by Learned Claimant's Counsel and Acusite. The evidence on record is that it was alleged that the claimant was absent from duty, but it was cleared in 2004 with another officer, that is GSC Umar II, by Exhibit C4A. Evidence on record is also that his salary was stopped after being cleared, that 4 years after he was invited to appear before a disciplinary committee on the 4th of March 2008, that on 14th of November 2008, Exhibit C5 for his personal emolument was submitted, that as requested by defendants in 2014, he produced a confirmation of a sick leave, and that in spite of his pleas and other interventions, he has not been restated or paid his salaries since May 2004. It is equally on record that the defendants were given notice to produce certified true copies of the said exhibit, but failed to produce same. In the circumstances, therefore, the probative value of the evidence adduced by the claimants outweighed that of the defendants, and as so holds. As can be gleaned from the evidence on record, there was no formal notice of suspension of the claimants by the defendants, but his salary was simply stopped and has not been back in office since 2004. Basically, the claimant was suspended from office and his appointment has not been terminated or dismissed by the defendants. Perhaps the defendants may be unaware of that this honorable court, by virtue of section 254C sub 1F of the 1999 Constitution as amended, has jurisdiction over unfair labor practices. When an employee complains of unlawful suspension, the complaint falls squarely within the realm of unfair labor practice. This court now has jurisdiction over same. In my humble opinion, the defendants are still wedged in the pre-3rd 3/3 alteration to the 1999 Constitution's dispensation of labor jurisprudence, where the orthodoxy of common law holds sway over and above the more pliable International Labor Organization ILO induced equitable norms of labor jurisprudence as represented by international best practices, and which by Section 254C1F and H of the 1999 Constitution as amended, this court is enjoined to apply when adjudicating. The locus classicus on the application of provisions of Section 254C1F of the 1999 Constitution as amended was decided in Mrs. Abraham Yetunde Merriam versus University of Ilorin Teaching Hospital, Management Board, and another citation supplied, wherein as Lordship Honorable Justice B. Kanyip, PhD, now the President of the Court, admirably laid down the current labor and employment jurisprudence in Nigeria, where he held, I quote, Section 254C1F and H of the 1999 Constitution as amended gives this court jurisdiction over unfair labor practices and also enjoins this court when adjudicating to have regards to international best practices. But where an employer acts outside the pale of bona fide, that is within the pale of mana fide, unfairness, vindictiveness, and victimization, as in the institute, then equitable jurisdiction of the court, which enjoins this court to do away with the rigidity of the common law in preference for the rules of equity, must necessarily be called to aid and assuage the hapless employee. And specifically given this court's jurisdiction over unfair labor practices, Section 254C1 of the 1999 Constitution enjoins this court to take a closer look at labor practices of the employers, even where it is internal, in order to ascertain the fairness or otherwise of those practices. And once found to be unfair, the expression of law is that the labor practice in question must be remedied as may be just under the law. Like I noted earlier, the essence of this court is not just the enforcement of mere contractual rights, but for preventing labor practices regarded as unfair, for which a vindictive suspension and a vindictive denial of refusal of promotion are but examples, and for restoring industrial peace at the workplace, end of quote. This honorable court is empowered by Section 13, 14, 15, and 19D of the National Industrial Court Act 2006 to award damages, where it comes to the conclusion that there is unfair labor practice. It is in this regard that must be viewed that the court has the duty to enthrone international best practices by providing remedies for the injuries arising from unfair labor practices. Clearly, for donkey years, the claimant has suffered deprivation and humiliation without just cause for his reinstatement, payment of salaries and other entitlements without redress, and finally instituted the present case in June 2021 in this honorable court be his last resort and hope. In my candid view, the non-payment of the claimant's salaries and entitlements for over 19 years is vindictive, oppressive, unjustifiable, and unfair labor practice. Probably this is the reason the defendants are clinging to any straw and denying the claimant is an employee to cover up for their failure to reinstate him and pay his salaries and entitlements after being cleared of the allegation of absence from duty since 2004. In the overall analysis, the courts are judges. The claims of the claimants as meritorious. Judgment is hereby entered in favor of the claimants against the defendants upon the terms set out as follows. A declaration that the refusal to recall or reinstate the claimant after he has been cleared of the allegation of absence from duty since May 2004 is unconscionable, unlawful, unfair, and unjust. 2, a declaration that the claimant's employment with the defendant subsists and that The refusal of the defendants to pay the claimants his monthly salaries and other entitlements since 2004 is unconscionable, unlawful, unfair, and unjust. 3, an order of this honorable court directing the defendants to immediately recall and reinstate the claimants. 4, an order of this honorable court directing the defendants to calculate and pay the claimant's salaries, allowances, and other entitlements from May 2004 till date. 5, the sum of 300,000 naira as general damages. 6, the cost of 200,000 naira is awarded against the defendants. 7, it is hereby further ordered that the defendants shall pay the sums set out in 4, 5, and 6 above to the claimants within 30 days. And 8, 10% interest is awarded on the judgment sum from the judgment date until final liquidation of the judgment sum. This is the judgment of court.
We are most grateful, my Lord, for this very well detailed and considered judgment, my Lord. Indeed, the courts, particularly the National Industrial Court, is indeed the hope and the comfort of the oppressed worker and civil servants. We are most grateful, my Lord.
Thank you. I hope the judgments will be ready by what's today's date? 27. I have a week to send it over. Let's see the dates when you can start applying. You can apply from the Monday today, because they need to transmit it to me, then I need to sign it. So you just have to bear with us. So you can call for it from the 3rd of August. It should be ready by 3rd of August, please. Thank you. Thank you. The court will rise, please.